And welcome to our breakfast briefing here with Von Briesen and Roper. Back with us is Jim Macy, John Iden, and Stacy. I should put my glasses on so I can read that. Gerber Ward joining us to talk about screening and protections, our legal considerations for employers, purchasing tests, and PPE for employees. So very timely topic again. These have been great for us, and we really appreciate Von Briesen and Roper in helping put these on for us. We just come along for the ride, so we appreciate the ride, Jim. So.
Well, thanks, John, and it's certainly our pleasure to team up with the Chamber, and it's been a pleasure for, I think, going on probably 30 years, quite frankly, that we've been able to put these programs together. Certainly a little bit different season this past season as we've adjusted to all the new changes and all the different things coming at employers. As John Casper mentioned, a couple of my other partners are joining this morning. John Iden, of course, he's with our employment law section and litigation sections. And again, as I said, he's one of the partners. And one of our other partners from Milwaukee, Stacy Gerber Ward, is also joining us. She is in our healthcare section. We represent quite a few healthcare providers, hospitals, nursing homes, and others. She's also in charge of our governmental investigation and corporate investigations unit. She's a past U.S. attorney for a number of years. And Stacy, thanks a lot for joining us today as we work on this particular topic. As John Casper also said, we're going to talk about screening and protections, PPEs, and all of those kind of things. As those of you joining us today, if you joined us last month, we took a very short break from COVID-19 issues and talked about something a little bit different. But the issues just keep coming in terms of this COVID-19 and what's going on with it. There were a lot of questions, a lot of interest in as businesses and public sector units are getting back to work. Is what's going on, what's the latest in the screening. A couple of my colleagues today are going to talk about changes that occurred even as of yesterday. It's changes as we go. I'm going to start out a little bit though and talk about personal protective equipment and PPE. I'm going to talk a little bit about what ought you consider as you're talking about what do you buy? What are you required to have on hand? What might the employees pay for? Can you require these kind of things? So we look to some of the frustration I know that you all have, and we do to some degree, is the extent that there isn't a great specific roadmap. This is really learn as we go under this invisible disease that we're dealing with. And that's okay. That's okay. We all work together. We all study. We all put together what we can, and we go to as many resources as we can so that we can advise and you can make determinations on what to do. One of the agencies we look to is OSHA. I know some of my public sector friends may say, well, OSHA doesn't really apply to us. Well, it may not, but it's still good. It's still good advice and things that you should look to. And then of course we pick that up from the public sector through some of the public sector agencies anyway. So it's good things to look for. Let's start with the realization that OSHA has not passed and does not have a specific regulation to deal with COVID-19. Those of you that deal with OSHA a lot know that there are many specific OSHA regulations that tell us exactly what to do in certain circumstances. Well, that's not the case here, but they did put out some advice. And as we have in the past, we'll circulate the PowerPoint we're using, and you're going to note in the PowerPoint that there's a number of sites within it. And I noted the OSHA one here on a publication that OSHA puts out that talks about COVID-19 and different suggestions and different things that it has with it. With that, they do say that even though there may not be any specific OSHA regulations, there are a couple to consider. Some of their specific regulations just in general. There is one, for example, which is 1910 subpart 1 that does talk about when gloves and eye and face protection may be required, or respiratory protection in certain businesses needed to protect those employees in those businesses. Some of our painting operations, certainly our healthcare operations, and others are going to have specific requirements that deal with that regulation. Next slide, please. Another OSHA regulation that comes into play is the overall catch-all, the ever popular general duty clause, which means if there isn't something specific, you may have some requirements under the general duty to furnish each worker employment, a place of employment which is free and recognized from hazards, either causing or likely to cause death or serious physical harm. Well, like I say, the ever popular because it's very broad. And when OSHA doesn't have anything else that it might latch onto, it could be this that impacts us. And OSHA points to it to say, under the COVID environment, this could come into play, and keep it in mind to the degree you're dealing with all the issues under COVID. We go to the next slide, please. OSHA also puts different jobs into categories based on the degree of exposure, the degree of risk. And they talk about, depending on the degree of risk, what might our requirements be, our responsibilities be. So analyze your business and your situation as to whether or not you fall into, for example, what they list here as a lower exposure risk scenario, where it doesn't require contact or very limited, and there's not frequent close contact. And when we talk about that, we're talking about people within 6 feet of each other, either with employees or within the general public overall. So, and they say if you're in this kind of environment, then PPE may not be necessary as far as that goes. But when you think about it, it's probably the limited circumstance that this may come into play. It can come into play, but that's the lower risk exposure. If we go to the next slide, their next level down is the medium exposure risk. And you're gonna, as you see, as OSHA describes this, there's more frequent or close contact where people may come within 6 feet of others. And we get the idea with social distancing, you're all gonna have rules for your employees to maintain social distancing in 6 feet. Is that realistic that it's always gonna happen? Probably not. Is that realistic that it's always gonna happen with your customers? Probably not. And you may find yourself in a scenario that's going to be more of this definition of the medium exposure risk. And even if, and OSHA talks about these scenarios is, are we in an area where there's quite a bit of exposure? They say that gets treated a little bit different. We're going to have more responsibilities. They say even if we're not in an area of a lot of exposure, if we have customers, clients, employees, or others that travel to other areas and come back to our area or our business, we may have a higher need for more equipment and other responsibilities. Notice that they specifically list into some of this, some others, like schools. Interesting that they would point that out within this medium risk exposure aspect of things. If we go to the next slide, please, John. When we get to the medium risk exposure and they talk about the PPE, they talk about factors that you consider in looking at what you may provide. So they're going to say, yes, you're going to have some responsibilities, and look at these kind of factors to see just what may come into play with that. And they say they may need to wear a combination of things. That may be gloves, it may be a gown, it may be a mask, shields, goggles. So now they're getting a little bit more specific as what this may be. And also notice that they say within your category of employees, some may have greater responsibilities Some may not. In other words, you may have and probably will have a group of employees that you're absolutely going to require to have masks, where others may not. Within this medium exposure, at least according to OSHA, there can be a difference in that regards. If we go to the next slide, pretty common sense. We get into the high risk, or what they call the very high risk areas, and Stacy, John will talk a little bit more about some of these, but when we get into the medical areas and things like that, where people are actually knowing they're going to be in contact with people with COVID, well, now we have much higher responsibilities, and that's just common sense. And so they talk very specifically about very specific equipment that we're going to need for that. Next slide, please. Another issue OSHA talks about, and we get asked quite a bit about, is who's going to pay for this? If you're going to require masks for all your employees, and you're probably going to have the ability to do that. In other words, if an employee says to you, I'm not going to wear a mask, that's probably not a decision the employee is going to get to make. Let me come back to that in a minute. In the meantime, though, to the degree that we require certain aspects of it, OSHA, going back to a regulation that passed late 2007 and implemented in 2008, so the general rule is going to be if we require, we may need to pay, or we'll have a responsibility to pay for that PPE. And then they talk about some of the typical things that you're going to see. If you go to a construction site, for example, you're going to wear a hard hat. If you go into some of our manufacturing facilities, you're going to wear safety glasses. That's just common to all of us. It's not so common as what we're doing in the COVID environment. We go to the next one, John. This is the rule that, like I say, late 2007, 2008 that came into play, that again made it that way. But note that they talked about safety shoes and prescription eyeglasses at the time, and they said these type of things, and these two particularly, when they're common use for people to use outside of the workforce, and it's okay that they do, then the employer doesn't have the same responsibility of absolutely paying for that hard hat. So there are differences. So let's put that in the context of a mask. If the mask is just general protection, it's not a very specific mask that you're requiring for certain purposes beyond just the general protection. If it's the type of mask they're going to wear to get into Menards, it's the type of mask they're going to need to wear to get into other places and wear anywhere. And we're not dictating within reason, other than First Amendment issues or other things that might be printed on the mask. If generally people can wear what they buy and it's okay, you may not have the responsibilities for the pay and the others. If you provide it, if you require a certain kind of mask, that responsibility goes up. Next slide, please. Separate from OSHA, another agency we look to is the Fair Labor Standards Act. And what I put together within a couple of these slides is some of the history and what the Department of Labor has talked about and when we have to pay for certain PPE and certain uniforms. And the closest analysis we can get are things like uniforms and shoes and other things like that. General rule is if we have a very specific uniform that we require, and like OSHA, if it's tailored just for this business, not for outside use or other things, then we're going to have a pay responsibility and we're not going to be able to deduct that from pay. And always be careful if you're doing any deductions from pay, but if you're doing deductions from pay that could result in less than minimum wage or overtime responsibilities, then you got a problem, okay? So if you're looking at that, be careful, but it's some of the issues that come into play with it. Next one, John, please. Again, if it's more street clothing, if we just require some kind of white athletic shoe or something like that that can be worn anywhere, that has not been an FLSA matter. The other type of things can be. And again, we'll always look to where's the primary benefit and convenience, and it's one of the tests under OSHA. It's under most of the agencies as far as that goes. I don't have a slide on it, but there's one last thing I want to mention with this, and that is the aspect of reasonable accommodation under EEOC guidelines and some of the other guidelines. There are scenarios, we've had them well before COVID, that we may require a mask. Certain painting businesses that we work with that require certain respiratory masks. We've had the scenario where someone medically is unable to wear the specific type of mask that we had. Does that mean that they can work without the mask? No, but it may mean, well, it does mean that we're going to have the interactive meeting and talk about just what we might be able to do to reasonably accommodate that medical scenario with the mask. So are we already getting the scenarios where a business says all employees wear masks and the employee comes in with a doctor's thing that says, oh, my patient is uncomfortable wearing a mask? Well, that doesn't quite do it. We're going to have to go into more of an analysis about that. And like any reasonable accommodation, if we can't reasonably accommodate, then they may not be able to do that job. I want to just mention that the last thing. I think my colleagues are going to pick up a little bit on that, and more of that as we get into the other aspects of it. With that, John, I would turn it over to you.
Thank you, Jim. The mention of the ADA is a perfect transition into employer testing. ADA and the prohibition on mandatory medical examinations is what has been guiding the EEOC as they as their guidance evolves as to what employers are permitted to do and can require of their employees. So just taking a brief step back to pre-COVID-19 and the ADA and its position on mandatory medical tests, it required that the test be job related and consistent with business necessity. Now again, pre-COVID-19, there was a very limited set of circumstances that permitted mandatory medical tests, and it typically involved employees whose medical condition or an adverse medical condition could pose a direct threat to health and safety of coworkers or the general public. So we saw mandatory medical tests permitted in some public safety positions, police officers. We also saw it permitted pre-COVID-19 in some heavy equipment operators, again with the idea being that fitness for duty is of the utmost importance when someone who is unfit could cause pose a direct threat to others. Now, applying that rationale to COVID-19, in March of this year, the EEOC issued guidance that said employers were allowed to ask employees questions about their medical condition, and specifically whether they were experiencing symptoms consistent with COVID-19, and they were allowed to perform mandatory temperature checks. And the idea being that while the employee questionnaire and the mandatory temperature check is considered a medical test or examination under the ADA, an employee who has COVID-19 and comes into the workplace poses a direct threat to their coworkers because they could get the illness from them, and therefore the mandatory temperature check and questionnaire met that standard under the ADA. Now that's the March guidance, and I think we were, shortly after that guidance was released, we went into safer at home, and most employers were operating on an extremely limited staffing basis, if operating at all. So I don't think during that time we saw too many employers implementing either option. Now as we return to work, and we've been presenting on this issue and counseling employers on what return to work looks like, we are seeing more and more employers go to the employee questionnaire to gather information before they start the workday about exposure and symptoms consistent with COVID-19, and we're seeing some employers do temperature checks. Now, when we talk about temperature checks, again, at least in my practice, and I think the same is true for Jim, we're seeing it on a fairly limited basis, large production facilities and long-term care facilities where a high-risk population exists, less frequent when we're talking about a medium to small size employer in office environment. But again, the EEOC has issued guidance permitting it in any context. We're just seeing it used in those limited areas. But the guidance on how to actually administer temperature checks is very limited. We have some general considerations that are issued by the CDC and the EEOC regarding privacy and confidentiality of the information that's gathered and PPE for the person administering the test, but no precise guidance on where the test should take place, inside or outside the facility, how frequent the test should be administered. Again, there's a lot of room for interpretation for every specific employer, and I think employers struggle with the idea of, I want to do a temperature check, but I don't know where to start. We don't have a roadmap from the EEOC or the CDC. It is entirely fact-specific and really is dictated by the size of the workforce that you're going to be testing and the makeup of your facility. Do you have a separate room available that could be dedicated for this process, or are you looking at setting up something outside in the parking lot? We've seen some employers do. But again, it's entirely fact-specific. So if you wanted to go down the road of temperature checks, there's some best practices here in the slides that you should consider regarding drafting a policy, communicating that policy to employees before you start administering the test, establish your temperature threshold so it's applied uniformly to all employees, identify the employee that is willing to take the test. If you have no willing participant who's willing to stand out there and take temperature, even though you're willing to provide the necessary PPE, consider the costs associated with getting in a third party. It wouldn't have to be someone highly specialized, but someone who's trained and comfortable in that role. Forcing someone to take temperatures is something that would have to be kind of evaluated in more detail. And then again, finally, the ADA consideration of confidentiality and general privacy concerns is something that's been reiterated by the EEOC and CDC. So that should guide, again, your considerations of where to administer it, how to store the information, how to ensure that these employees just aren't standing in a large group and everyone hearing their temperature and seeing someone being sent home if they're over 100.4 degree temperature. The much more common tool used for screening employees that we've worked on is the screening questionnaire, again, permitted by the EEOC guidance, and it focuses on questions related to whether or not the employee is currently experiencing symptoms consistent with COVID-19 or has been in direct contact with someone who is either experiencing symptoms or tested positive for COVID-19. The considerations when evaluating whether or not to implement an employee questionnaire include the frequency of the questionnaire. Are you doing this on a daily basis, on a weekly basis? I think it makes a lot of sense to do it Monday after people have been off work, on vacation, out just perhaps going to bars or seeing family or friends. Doing it on a Monday, I think it makes a lot of sense. Doing it every day of the week, that's a fact-specific analysis. I know my weekly routine, once we hit Monday, I see my family and the people I work with, and I guess the people that work at the daycare. But my answers to that questionnaire are not going to change Monday through Thursday. So is there value in having employees do it on a daily basis? Again, that's fact-specific for each employer. Security and storage of the data, again, confidentiality considerations under the ADA. And the time spent completing the questionnaire, the Department of Labor has indicated, is compensable time. So this impacts the frequency of the questionnaire, this impacts the length of the questionnaire, because this is going to be something that the employees do on the clock and are paid to do. So another consideration when you're thinking about, again, what type of questionnaire and how to administer the questionnaire. So that's where we were as of March. You were allowed to ask questions about symptoms. You're allowed to do mandatory temperature checks. As testing for COVID-19, specific testing for COVID-19 continued to evolve, the EEOC guidance evolved. And in April, the EEOC updated its guidance to say that you could have mandatory COVID-19 testing to identify whether the employee currently has the virus before they're returning to work. So you could require an employee to test negative before coming into the workplace. But the concept of COVID-19 testing and what is being tested with each specific test is somewhat of a nuanced issue. And there are different types of tests, and different types of tests have received different treatment by the EEOC. And what I just described, testing for the active COVID-19 virus, is generally referred to as a viral test. The EEOC issued updated guidance as of yesterday, in fact, that said the antibody test is not permitted under the current EEOC guidance, and they relied on the CDC opinion on antibody testing, which we'll talk more about. But in order to appreciate the nuance in the EEOC guidance from April, which permits COVID-19 viral testing, and the EEOC guidance from yesterday, which does not permit COVID-19 antibody testing, you need to understand what are the differences between these two tests, what is actually being tested, what is the value of the data being gathered, and how is this likely to evolve. Those are some of the issues that Stacy and I are going to talk about, but specifically, Stacy's going to walk through the different type of COVID-19 tests that we're seeing available on the market or being developed by third parties.
Thanks, John. Just to reiterate John's comment, that the technology on COVID-19 tests is evolving almost daily. And so what you're getting today really is a snapshot. So going forward, it's likely all this information is going to have to be updated. As John mentioned, there are really two types of tests that we want to talk about. There are viral tests and there are antibody tests. There's been a ton of media about the antibody testing. And so because that causes a lot of confusion, we really want to be clear about the differences between the two. So the first type of testing that we're going to talk about are the viral tests. These are the tests that you often see on the news reports. It's either a nasal or a throat swab in terms of how the sample is taken. Those samples then are being sent to a laboratory to be tested. A viral test determines whether or not there's an active infection in the individual. And there are two types, and again, this causes some confusion. There are two different types of viral tests. There's what's referred to as PCR testing, and then separately there's antigen testing. And we'll talk a little bit about the difference between those two types of tests. So next slide, John, please. So the first type of testing is the PCR testing. This is really the gold standard currently in testing. It is FDA approved. And what the essential mechanism for PCR testing is that it's looking for the virus's genetic material. So it has a very high level of specificity and sensitivity, meaning that it's very accurate in terms of its results. The downside is that PCR testing currently takes at least 1 to 2 days to get the results. So currently it's not a very fast turnaround. However, there are very recent developments in terms of what are referred to as high throughput technology, which can make the results available in 3 hours. This is basically technology that allows labs to test a high volume or a high number of tests all at once and to get those results very quickly. Testing is really just coming out right now, and I'll talk a little bit about the reimbursement for that later. It's quite a bit more expensive right now. So next slide, please, John. The second type of viral testing is antigen testing. So the mechanism here is antigen testing. Rather than looking for the DNA of the virus, it's looking for certain proteins on the virus. So just a different mechanism for the test. This testing is actually much quicker, but it's less sensitive. And what do I mean by less sensitive? Less sensitive means is that there can be false negatives that result from the test. So if you're using antigen testing right now, it's often recommended that a negative result is then confirmed with PCR testing. So that's obviously, although it's much quicker, it requires an additional level of testing and can be more expensive. The first antigen test, just received an emergency use authorization, or EAU, from the FDA on May 9th. And in a minute, we'll talk about the significance of an emergency use authorization from the FDA. Despite the fact that antigen testing is so new and not FDA approved, the statements that were released by the FDA when it issued the first EAU just last week were very positive, and the FDA is really enthused about the future of this testing. Again, one of the huge benefits of antigen testing is the quick turnaround, really just hours rather than days. So again, this is one of those areas where it's very likely that technology is going to be emerging quickly. I think the government is spending a lot of money helping companies develop this type of testing, and really sees this, I think, as being the future of testing where we can get the results very quickly. So next slide, please, John. The second sort of big category of testing is what John referred to earlier, and that's antibody testing. Antibody testing is different than the viral testing because it's not determining whether or not an individual currently has an active infection. The antibody testing is determining whether the individual has been previously infected by the virus. And so there is a lot of hype over these tests because the manufacturers are sort of touting these tests as helping determine if you have potentially have an individual who was asymptomatic but was still exposed, whether they are currently immune to the virus, right? So that potentially has a lot of implications for employers. The antibody test is different also than the viral test in that it's administered, it's called a serology test, but it is one that's administered by taking blood from the individual. So you typically need some sort of medical personnel to take that test. And similar to the viral test, those tests still have to be sent to a lab to be analyzed and get the results. The antibody testing is only currently available under the emergency use authorization from the FDA. Again, it's not FDA approved. It is simply being authorized for use by the FDA. Okay, so let's talk a little bit about specifically what that means in terms of the FDA issuing EAUs. EAUs are a mechanism for at least preliminarily approving medical products during a time of an emergency. So you don't hear about EAUs unless we have a declaration of an emergency essentially in the country. So this is really a unique circumstance right now where the FDA is using this methodology with quite some frequency right now. So under an emergency use authorization, what the FDA is looking at is whether the device or product may be effective. So if a medical device was going through the normal FDA approval process, the product or the manufacturer must demonstrate that the product is safe and effective. So the absolute standard for approval is the effectiveness of the product. Here, under an emergency use authorization, the FDA the manufacturer just has to establish that the device or the product may be effective. And when the FDA is making that determination, what they're doing is they're looking at whether the known and potential benefits outweigh the known or potential risks of the product. So again, it's a lower standard, and the FDA is not doing any sort of independent analysis of a product. They're simply looking at the data that's being submitted by the manufacturer in terms of determining whether or not it meets that bar. So it's important to understand sort of the significance of what that authorization is. So next slide. So again, the antibody testing, again, is available only under an emergency use authorization right now. And so as John mentioned, there had been quite a bit of hype when the FDA first started approving or issuing the emergency use authorizations for these products because it was thought to sort of be of great assistance to employers in terms of helping determine which employees could return to work. If they had a positive antibody test, the thinking was, hey, these employees are immune and we have much less of an obligation to provide protection for these employees in the workplace. However, it's becoming really clear that there's a lot of limitations on a positive result for antibody testing. And currently, the tests the current state of the sciences is that they don't reveal whether the antibodies are the kind that can prevent another infection, right? So the antibodies in the system do indicate that there's some level of immunity, but the science just hasn't evolved enough for us to be able to say that if you have a positive antibodies test, that you in no case could be susceptible to another infection. The other question that the antibody test does not definitively answer is, even if you have the antibody in your system, the science just has not established how long the protective immunity will last against another SARS-CoV-2 infection. So the use of the antibody testing currently, the science is that it just has, it has limited utility right now. And I think John's going to talk a little bit more about that in the context of what the EEOC is saying. So I'll turn it back over to you, John. Oh, I had one more slide, sorry. We just wanted to mention, right, as employers are trying to evaluate whether it makes sense to do testing in the workplace, you know, one of the big concerns has been cost. You know, there was quite a bit of press within the last couple of weeks about what Amazon is doing in some of their plants and some of the projected costs of testing their employees. So there's not a real clear answer on this. You know, laboratories, frankly, in this country are free to charge whatever they want. So if you went out and got quotes for different types of tests, you're probably going to see a lot of variation. I would say, you know, we thought it might be useful to throw out there what Medicare is currently reimbursing for these tests, right? I mean, it's well known. Medicare often does not necessarily cover the full cost of a test. So this isn't a perfect gauge, but it'll give you at least some benchmark by which you can gauge the cost of testing. So Medicare is currently reimbursing for both viral and antigen testing between $42 and $54 per test. That high throughput technology I mentioned earlier for the viral testing is currently being reimbursed at $100 per test. And that guidance just came out, I think, within the last week or so. So that'll give you some sense of what the range of, at least what the government is currently reimbursing for those tests. So John, I'll turn it back to you now.
Thank you. So as Stacy said, the testing arena really is the Wild West right now. I think there's a widespread desire in every arena, whether it's government, employers, general public, for the ability to simply take a test and know. We're hearing so much about symptoms and contact tracing and 6 feet, and wouldn't it be nice if I could just have a nasal swab and know definitively? And that's what's driving the market, and the first to market with something that's easily accessible, point of care, and can give you an answer in short time. I mean, that's the $1 million idea. That's what everyone's scrambling to accomplish. And when I say point of care and accessible, I mean something that's relatively low cost and that can be administered at the workplace and give you an answer in a reasonable amount of time. That test does not exist right now. And Stacy can correct me if I'm wrong, but everything that the CDC is issuing and every context where employer testing or, COVID-19 testing is discussed, it's through conjunction with or coordination with a healthcare provider. And you're either bringing in a third party with licensed healthcare providers who can administer these nasal swabs and sample collection and have sanitation practices in place to ensure there's no cross-contamination of samples. This is being done by professionals, or you're sending them to your employee to a local employee laboratory where they're doing drug testing, and maybe some of those are offering COVID-19 testing currently. But again, this is not happening at the workplace currently, but that's on, I'm sure, every test developer's radar, getting something that's widespread and accessible. So back to the EEOC guidance that we're currently operating under. We have the guidance from April says that employers may require employees to test positive through a viral test before returning back to work. Employers do need to ensure that tests are accurate and reliable, and for that, the CDC has recommended that the employer look to the FDA and the emergency use authorization. Now, the more I learn about the EUA process, it's not a very high bar based on my non-scientific reading, and as Stacy described it, it's what tests may be effective and do the benefits outweigh the risks. So the bar for a quote accurate and reliable test is an FDA EUA, which is not a very high bar. So I think that's one point to make for employers who are looking at evaluating COVID-19 testing and the costs associated with it. What is the value of the data that you're getting, and is it accurate and reliable? Yes, in a legal sense. I mean, you're meeting the EEOC requirements and you're using a test that has an EUA, but understand what EUA means and the reliability that comes with that. And then also the value of the data. For me, looking at this, or if I'm counseling an employer on whether or not they should do viral testing, my biggest concern from an employer perspective should be the value of the data, in that it's a snapshot in time regarding whether there is an active infection in the employee at the moment that the test is taken. And the CDC has clearly stated that a negative viral test does not mean the employee or the individual does not have COVID-19. It means they do not have an active infection at that time. So an employee who tests negative on Monday could have COVID-19 and it's just not active yet, or they could come in contact with someone on Wednesday and they would have COVID-19 on Friday or maybe the Monday after. So it really is just a reflection of that moment in time from the testing perspective, and it is not in any way an assurance that, well, this employee isn't going to have it or be a direct threat to other employees in the foreseeable future. So to the extent that these tests require taking up a lot of time with on-site collection, or even more time sending employees to a third-party facility for a laboratory sample being taken, and then to get the results back to know that on that day they didn't have it, but that doesn't say anything about tomorrow or the next day, that's something, again, to keep in mind when you're evaluating the decision to administer the test. I think the CDC recognizes the limitation in this data, and for that reason, their recommendation is that viral testing not be used as a screen before everybody returns to work from vacation or before anyone comes back to work, but rather that the viral test be used as part of a return to work protocol. So you have a policy in place where employees are screened through a questionnaire before they start every day. And your policy says that an employee who reports having symptoms consistent with COVID-19 is sent home for 14 days unless they remain symptom-free for 10 days or unless they can return to work with a negative test stating that they don't have COVID-19. Now, the test that employee would go get to verify that they don't have COVID-19 would be a viral test. And the CDC, again, because a negative viral test on Monday doesn't mean an absence of COVID-19 on Wednesday, the CDC has recommended that the return to work protocol for an employee who has symptoms consistent with COVID-19, that it include a negative viral test followed by a subsequent negative viral test 3 days later. So as with all the guidance that we've presented on related to COVID-19, there are levels of compliance that employers can abide by due to limitations in time and resources. And can an employer have a policy that says you have symptoms consistent with COVID-19, you're off work for 14 days unless you have 2 subsequent viral tests indicating you don't have the virus? You absolutely can go to that level in verifying the absence of COVID-19 before returning an employee to work. A less scientific and less costly approach would be to tell an employee to stay off of work for 14 days, assuming they've remained symptom-free for at least 10 consecutive days. There's some variation of a timeline based on the experience of symptoms. So where you as an employer are in this spectrum of evaluating an employee's ability to return to work, either through questions, the presence of symptoms, or actually conducting COVID-19 testing, that's for each individual employer to evaluate. What the CDC has issued guidance on is kind of a gold standard, in my opinion. And what the EEOC has said from an employer reliability and the ADA analysis is you have the green light to conduct temperature checks, to ask employees questions about symptoms, and to perform viral testing. So you have the tool in your toolkit. How you use it, again, is a fact-specific analysis for each employer. What we do know at this time is that employers are not allowed to require antibody testing before an employee comes back to work. And some of the discussion that I've seen from the EEOC is that the exception to the ADA prohibition on medical examinations is for the limited purpose of identifying a direct threat to coworkers. And the antibody test does not test for active infection, and therefore you're not testing someone to determine whether or not they're a direct threat. You're testing someone to determine whether they had COVID-19 in the past and as a result have developed the antibodies. I personally, under that analysis, the antibody test would never get acceptance from the CDC or the EEOC under the direct threat analysis, because the antibody, by its very definition, is never testing for an active infection. I don't think that analysis is going to prohibit the endorsement of antibody testing once that technology is accurate and reliable. My reading of the CDC guidance and the EEOC guidance, they both leave open the option or the ability to incorporate antibody testing in a return to work protocol when the accuracy and the reliability of the data is firmed up, or when we have more science on that issue. I believe that their hang up is not on this direct threat analysis. You're not testing for active infection. It's that the CDC isn't convinced what the or doesn't know what the significance of the antibodies are. Does it mean that you won't be reinfected? And if it does mean you won't be reinfected, how long is that true for? Do you have the antibodies for a matter of weeks, a matter of months, or indefinitely? And the science is unsettled on that issue. So I think that in my, again, reading of the EEOC guidance, there's no assurance that antibody testing will be permitted, but based on the trajectory of how the CDC has evolved and the EEOC has followed suit, the CDC it seems willing and able to give employers every tool available that's accurate and reliable to protect its employees. And I think the antibody test is of tremendous value, primarily because it is not just a snapshot in time. Once the science is developed, we will be able to say to a reasonable degree of certainty that it means this employee is immune from reinfection for X amount of time or indefinitely. And that is a much better piece of data when you're trying to evaluate risks and potential risks in a workforce than, again, the snapshot in time piece of data that is presented with the viral test. If you can antibody test your entire workforce and identify 25% of employees that have the antibodies, well, they're your superheroes in your workforce. I mean, they're immune from reinfection if that's what the data bears out. And the CDC knows that's what the data means or potentially means. The CDC knows that once an antibody test is endorsed, you will have people who have the antibodies who are dismissive of all the other precautions that need to be taken and will view themselves as superheroes. And I think that's the primary reason why they're being more cautious with the antibody testing. I mean, antibody tests have EUAs, no different than viral testing. Viral testing is endorsed, but the antibody is not. And myself, reading the tea leaves, I think it's because they're not ready to release the antibody testing, endorse the antibody testing, because they're simply unsure whether or not the antibodies truly do prevent subsequent infections. But to Stacy's point, this is rapidly evolving almost daily, and I fully anticipate that science will continue to develop. And I believe, again, based on the trajectory and the evolution of CDC and EEOC guidance on employer testing, that we will see antibody testing embraced as another tool in an employer's toolkit for managing a workforce.
Thanks, John. Appreciate that. And Stacy, a couple of things, what does all of that mean for us now, today? And we've given you a lot of information about how this science and how these tools are developing, and stay tuned as we'll continue to update. But let's step back for a minute. So what do you know coming out of today? For those of you that are working on bringing your workforce back in a reopened policy, consider what tools you now have available to you, either through PPE, and evaluate what you want to do and who's going to pay for it. And then also what type of screening that you want to do. And as John refers to it, and he's right, it's a snapshot in time. And there are going to be, whether it's temperature testing, that'll tell you at least what somebody's temperature is coming in and one of the symptoms, and we can do that depending on cost, depending on technology. A survey, you may do that. And there's a question here, and I'll open this to the panel in terms of, can we do a screening questionnaire like as a one-time document coming into the workplace, and then expect that employees are gonna know they can't come to work if they have symptoms? And my initial response to that, and I asked the panel as well, is certainly you want to do a document, you can do an initial one-time document, and should do an intro back into the workplace screening mechanism that might include that survey. Stacy or John, any follow-up to that?
Yeah, I completely agree. If someone is just coming back off a remote work accommodation, or excuse me, a remote work due to safer at home, I think the questionnaire upon their return is essential, just to know what exposure, if any, have you had while you haven't been in the workplace. Absolutely. And then as far as the point of saying like a contact information sheet that HR gives you, let us know if your address or your phone number changes. I mean, you could treat the employer questionnaire that way, or you could do it more frequently. I think that's completely up to the employer. I do think that putting it in front of the employee on a somewhat regular basis brings it to the forefront of their mind and reminds them and makes them reflect back and think about whether or not they've had any exposure, versus expecting them to voluntarily bring that information. But again, frequency of questionnaire is up to the employer.
It'll depend on the business too. I mean, it's just not going to be realistic for some businesses that we do it every day. In other businesses that we have where there's higher risk issues and higher exposure issues, our food processing businesses and other things like that, we're doing more regular testing, more regular surveys, I should say, and other type of things. And others where there's a lot less contact or a lot less exposure issues, probably not. Another question that came through was sort of protections, liabilities. I'm going back to work and I'm a salesperson, so I'm out on the road, and what liabilities, what considerations might I have in that regard? Well, there are liabilities and there are responsibilities that are going to go with all of our businesses, us included, that go out on the road. You know, I don't tell people when I have work done at my house what I do for a living. And it's always interesting for those of us in the business that now run into lots of people, because our antennas are way up as to what we see. So a contractor stops at the house the other day, and there is no PPE. There is no social distancing. And salespeople love to shake your hand. And in some of our culture and some of our ages and stuff like that, it's embarrassing or uncomfortable not to do that. But my gosh, I mean, it was real obvious to me right away that maybe there needs to be a little more discussion on that end of precautions and just some of the basics to keep in mind on that. Are there liabilities? Of course. If there aren't any precautions taken and we're exposing customers to liability, to COVID, we may have liability. Hard to trace all of that, but sure. Any other thoughts from the panel?
No, I think that's right. I think it's a duty of care analysis, and when you're out on the road from a legal standpoint, exercising reasonable care, and then from a more practical standpoint, just kind of exercising extra exercising care until the person that you're working with or the client that you're servicing indicates that it's unnecessary or they feel comfortable. That's the dialogue that all of us are engaged in right now on a regular basis. When you go to the store, when you deal with coworkers, when you deal with clients, everyone has a little bit of a different position on the precautions that they think are reasonable. And I think, especially in a service industry, being willing to adapt to their desire is a good approach.
I can comment too on the temperature testing. I have experienced that now in going to a business where we came in and automatically you step over a certain area. And I wasn't even told, I didn't know, but they just said, you got to step over here and look into this camera. And I thought they were taking my picture, which was a nice thing, not necessary, but a nice thing, and stand on these little footprints. And all of a sudden, this big number pops up in terms of, and oh my God, it's my temperature. Well, that's okay. And then I knew for the first time that's what it was about. And thank God that I passed. Well, and it was semi-discreet. It wasn't that anybody else could see the screen, but then I was starting to think, what would have happened if it would have been 101 or whatever above the threshold? What would they have done and what provisions are in place? And that's what we want you all to think about today. Who's setting that up for you? And then what do you do about it? I didn't know if a horn would go off, so I'm back at this place again last week. Now I know what I'm doing, looking into the camera. And I got to tell you, now I'm a little nervous going, my God, what if I'm 101? Because now I know what it's going to be. So there is a little bit of uncomfortableness for employees and others as they're going to go through that. So keep in mind the discretion, keep in mind the confidentiality, and have a discreet way to deal with how you're, thank God I passed again, and some whistles and horns and other stuff didn't go off. But keep it in mind, because that goes back to what John was talking about of as you do those. Are we going to get to that point in history where that's going to become the norm? Probably. After 9/11, everything changed about going on a plane. Everything's going to change again on going on a plane now. I think we're going to get used to having temperature checks and other kind of things as the technology comes into play. Other thoughts from the panel?
I think that's it for me.
Okay, well, John, on behalf of our team, we certainly want to thank the Chamber and thank everyone for participating today. I would toss it back to you at this point.
Well, yeah, thanks again. That was great. And Jim, actually, you cleared something up for me. I went to one of those companies too, and I sat on there and the number came up. I thought that was my IQ that was coming up. Thank God it was my temperature. I have higher expectations of myself. But,
did a horn go off?
No, it didn't. Everyone just kind of shook their head, though. I don't know. But thanks again for joining us, everyone. Great program as always. I see we are recording this. This will be on our website. So if you want to go back and refresh yourself, that'd be great. I think Mark will be in our office. Will be forwarding the link on to all the participants. So again, thank you all for joining us, and we'll keep these going. And thanks again, Jim, John, and Stacy. Great program.
You're welcome. Take care.
you.